our coverage of the 2020 presidential election petition that's been going on at the Supreme Court for about, say, 17 days now. And today we're going to continue with that particular coverage, starting a brand new day, starting a brand new week. Hope you're doing well this morning, and we're so grateful that you've allowed us in your homes and wherever you're watching us this morning. This is Ghana Television. It's also GBC News, and we are live on Unique 95.7. We're also live on Facebook, which is Ghana Broadcasting Corporation, on the internet, gbcghanaonline.com. And if you're listening to us outside the Greater Accra region, you are listening to us on all our regional community and community FM stations. My name is George Sapo.
And my name is Morris Sogbete. Good morning once again. And so today in court, primarily, the court is going to hear the legal addresses, per the indication that we have, hear the legal addresses of both sides, and also set the date for the ruling, and finally bring the election 2020 petition hearing to an end. But even before that, we have received a motion filed by the petitioner to review the 16th February ruling, and that particular ruling threw out a motion by the petitioners to subpoena or open their case and subpoena the EC chair to appear in the box and testify. That particular motion was thrown out. And so the petitioners this morning are seeking to review the 16th February ruling. Don't forget that they've done a review of the 11th February ruling, and that also was dismissed. And so today in court, these are the major activities that we're going to see. Also, because the petitioners couldn't file their legal address when they were supposed to do so, that was the last time the court sat. The Supreme Court was very charitable, and they've told them to bring their legal address today. We see how that also goes. And so basically in court today, it's going to be the hearing of the legal addresses and also a review of the 16th February ruling that was made by the Supreme Court. As time goes on, we'll take you through that particular ruling so you understand exactly what the court said.
All right, just to take you a step back, remember when the petitioner was done with his witnesses, 3 of those witnesses, and the first respondent rose and said that, well, they don't intend to call any witness, and likewise the second respondent. And based on that, the petitioner did not really take that lightly. So the following day they had to come to argue that out, and the court held that the respondent cannot be compelled to give a witness. So for that matter, if the first respondent and the second respondent have closed their case, then that be it. The petitioner did not take, again, that likely to it, so they sought for reopening of their case based on that, so that at least they can subpoena the first respondent. Again, a ruling came out saying that they cannot reopen their case, and so for that reason there is an application to review that ruling saying that they cannot reopen their case.
Right. And so George, you captured that particular ruling I mean, very well. And it says that this is by court, and this was the ruling on the 16th.
Yes.
It says by court. When the petitioner in this case closed his case with the testimony of his third and last witness, Mr. Robert Joseph Metonunu, on the 8th of February 2021, the court, as our procedural rules on trials provide, called on the first respondent to open its defense by the calling of a witness whose witness statement had already been filed on the orders of the court. The witness happened to be the chairperson of the first respondent, Mrs. Jane Adukwe-Mensah. Counsel for the first respondent told the court that he had weighed and scrutinized the case of the petitioner and presented by his 3 witnesses, and in his view the petitioner had not provided any substantial evidence in proof of his case, for which the first respondent had to mount the witness box to testify in answer. And so, I mean, basically that's the summary of that particular ruling that was made by the justices on the 16th of February, which the petitioners are seeking to review.
All right. Now, the motion for review reads, motion on notice for review of ruling dated February 16, 2021. Article 1331 and Rule 56 of the Supreme Court Rules 1996 CI 16. So that's the title given to that particular motion. We'll move to, I guess, Dr. Kweku Ajiman-Budu, who is a lawyer. He's a law lecturer. He's also the head of Law Center's Gimpa Faculty of Law, and he's the founder and executive director of the Justice Foundation. He's joined us via Zoom. We'll start talking to him when it's 9:30 and the court is ready. We'll take you to the Supreme Court. Doc, good morning.
Good morning, George. Good morning, Morris. How you all doing?
We're fine. How are you too?
I'm doing well by God's grace. Thank you.
You're looking good and all made up.
As always.
I know, right? Now, let's take about 2 or 3 steps back from Thursday, and then we can move into what to expect today, although there's a review for today. So Thursday, there was also a ruling. There was a review, then later there was also a ruling and all that. Let's just go back a bit, then we can continue.
All right. So on Thursday, the court was faced with or had before it an application that was brought by the petitioner applicant, and basically the petitioner applicant was seeking to have the court review its initial ruling that it had given in relation to an objection that the petitioner had taken in relation to the respondents choosing not to adduce evidence or call any witnesses and also close their case. You remember that the court had earlier on ruled that the petitioner or the respondents could indeed close their case and that they could not be compelled to adduce evidence at all costs. And the court basically based this ruling on the provisions of Order 38, Rule 3E of CI 87, the High Court Civil Procedure Rules, that deals with witness statements generally, and in particular, Rule 3E1 and 3E5, which basically provide that a party can file witness statements or allow witness statements to be filed on their behalf, but it is also possible that the party will not rely on the witnesses or the witness statements that have been filed. And so when such a situation occurs where a party has filed a witness statement but chooses not to call that witness to give oral testimony or to give testimony in that regard, then the other party has the opportunity to put in that witness statement as hearsay evidence. So the point is that the witness statement, as long as the person who authored that witness statement has not been called into the box, sworn in, for the witness statement to be adopted as that person's evidence in chief, that witness statement is not evidence before the court. And the rules clearly provide that it was possible that a party may allow a witness statement to be filed, but may decide not to call that witness. And on the basis of the rules and laws applicable in trials generally, a party could not be compelled to at all costs open his case. And we also know about the fact that a defendant in a civil suit can even make a submission of no case at the end of the plaintiff's case and can also decide not to adduce any evidence. And in this particular instance, the plaintiff or the respondent suggested that on the basis of everything that they had heard and all the evidence that had been adduced so far, they did not see it necessary to open their case, and that the court should decide the petition on the basis of the evidence before it. And so that was the ruling of the court, that indeed the petitioner or the respondent could close their case, and that was what the petitioner applied for a review of that particular ruling, and that is what we saw happen on Thursday, that the court essentially upheld its initial ruling and suggested that the petitioner had not been able to convince the court that indeed the respondent should be made to open their case. That's the essence of the ruling which came in on Thursday. And a number of reasons why the court arrived at that particular decision. The court, first and foremost, set out the main issue that was before us, which was the objection that had been raised by counsel for the petitioner in relation to the respondents deciding to close their case. And the petitioner's argument was that by virtue of the witness statements that they had voluntarily filed, they had elected at that point to adduce evidence. And that's what the court disagreed, and the court came to a contrary conclusion on the basis of the rules applicable, which I just set out in terms of witness statements. So that, in a nutshell, was what the court decided. They considered everything that had been argued before it and came to the conclusion that they were of the considered opinion that it would be wrong in law to hold that a party is deemed to have been elected to adduce evidence as soon as that party files and serves a witness statement in compliance with the court's order. And so that basically was the ruling, and the court reaffirmed this ruling.
All right, so Doc, when we return, I would like you to throw some more light on Article 133 and Rule 56, which are the basis for this particular review. But before then, we'll go to the forecourt of the Supreme Court, where our colleague Abdul Hai Mumen and the team are standing by to bring us up to speed as to what's happening, who is arrived, who is not arrived at the Supreme Court. Let's go to Abdul Hai Mumen. We'll be back for the discussions.
For the rerun to be organized between him and the first respondent, in this case the EC. Of course, the court allowed the petitioner to go and make those corrections, but as always, of course, the hottest bone of contention in the last fortnight has had to do with whether or not the chairperson of the EC, Mrs. Jane Mensah, should be cross-examined or not. This has been the bone of contention in court for a number of days, and she is currently arriving in court. Mrs. Jane Mensah is the chairperson of the Electoral Commission, of course, always in court together with her deputies, Dr. Bosman Asari, and currently also, and when you begin to see these scenes ahead of the sit, and this is beautiful. That's lawyer Joyce Bawa Mokhtari. She is the spokesperson to the presidential candidate of the NDC in the 2020 elections, together with the president's lawyer at the Jubilee House, and they were having a very lively conversation even as they were making their way into the courtroom. And that tells you this is a battle of intellect and not a battle of fists, so to speak. But taking it back to the reasons for which we are here, it has to do with the election petition. Of course, I've already given you a brief background, but specifically for today, we're looking forward to two key issues. The first is the fact that on Friday, the 19th of February, the petitioner's lawyers made an application to the court for a review of the court's decision not to allow them to reopen their case. You'll recall that after the petitioner had closed his case, and that was after the cross-examination of the key witnesses of the petitioner, in this case the General Secretary of the NDC, Mr. Johnson Esedun Ketia, and then the other person who was in the strong room of the EC, Dr. Michael Kwesa-White, and his colleague, Mr. Robert Joseph Metal Nunu. These were the three key witnesses who were cross-examined by lawyers of the first and second respondents in this case. You would recall that right after the third witness was cross-examined, both respondents, in this case the first respondent and the second respondent counsels, brought to the notice of the court that they would not be making available any witnesses, and that decision took the petitioner's lawyers by surprise. Indeed, the petitioner's lawyers themselves, led by Mr. Chachuchi Kata, did indicate that they had been surprised by that decision because earlier indications, even notices given by the court, statements made by the court itself to them suggested that that opportunity would be granted for the chairperson of the EC to be cross-examined, but the councils did indeed indicate that they were not willing to. Following that decision by the councils, the lead counsel for the petitioner then applied to the court to be allowed to reopen his case in order to be able to subpoena the EC chairperson to be cross-examined. You will also recall that the refusal, so to speak, of the respondents, the first respondent in particular, to make available a witness is what led to the decision by the lead counsel for the petitioner to apply to the court to reopen his case. After several arguments and debates in court, making references to legal precedents and other matters related to law in court, from all sides, talking about the petitioner making his case and the first and second respondents also making their case, the court ruled that it would not permit the petitioner to reopen his case. And that's what has brought us here today, because on Friday we cited documents that had been submitted to the court by lawyers of the petitioner, indicating that they wanted the court to review its own decision, the decision it took. This would be the third time the petitioner is asking for a review of a decision by the court. Indeed, we know the two previous occasions the petitioner asked for a review, both reviews were dismissed. The panel of 7 was changed to a panel of 9 on those two occasions, and the unanimous decision had always been the fact that the petitioner's request for review did not have solid grounds. Mr. Frank Davis is a member of the legal team of the I beg your pardon, the second respondent, in this case, Nana Adodanko Kufado. He has also just come in, and when the persons who are central to the case begin to make their appearance in the court premises and walk into the courtroom, that always gives an indication that sitting is just about to begin. And so in the last fortnight, the controversy has been around, indeed, whether or not Madame Jane Mensah should be cross-examined. The petitioner insists that Madame Jane Mensah should be cross-examined. This is because, according to the lead counsel for the petitioner, during the cross-examination of the 3 witnesses of the petitioner, Mr. Johnson Esedun Ketia, Dr. Michael Pesa-White, and Mr. Robert Joseph Metal Nunu, that some allegations did come up, and those allegations can only be answered by the chairperson of the EC. But the court has ruled that a party cannot be compelled to give witness if that party so wishes not to do so, and that has been the controversy, and the court arrived at a decision. The decision is what the petitioner is asking the court to review today. Meanwhile, the court had earlier on asked, of course, okay, so the court is just about to start. So Nanabi is one of the spokesperson of the legal team of the respondent, has also just come in. So we'll go to the courtroom right now and bring you more details later on.
Respectfully, my lords, writ number J1/5/2021, John Dramani Mahama versus Electoral Commission of Ghana, Nana Abudankwa Akufo-Addo. Please, who is representing the petitioner? Please. My lords, Nana Opoku Agyemang is representing the petitioner. Electoral Commission of Ghana, my lords, Jane Mensah, chairperson, representing the first respondent. Peter McMahon, my lords, is representing the second respondent.
It please my lord, Tony Lither for petitioner applicant. My lord, I'll be led by Mr. Chikaka. He's just stepped up with me, should begin in a minute.
Yes. May it please the court, Justin Amenvo appears for the first respondent with Alexander Samoa.
If it pleases your lordships, I put on call for the second respondent. My lords, with me are my learned friends, Frank Davis, Kwekwe Sifi, and Yao Pong.
Yes.
My lord, there are two applications scheduled for this morning. One is the stay of proceedings. In view of the fact that both are scheduled for today, and the review will be taken today, I crave your indulgence to withdraw the application for stay of proceedings. Oh, okay.
The extension of time. It should also be before the ordinary bench. So that was why we decided that we can take. The lead counsel is now in. Yes.
Very well.
You can take the review.
So Mr. Chikata will take the review.
My lords, respectfully, we have an application for review before your lordships.
Time management, you have 30 minutes.
Very well.
And there will be no extension of time.
I'm sorry, I didn't hear that.
There will be no extension of time.
The application for review is brought under Article 133(1) of the Constitution and Rule 56 of the Supreme Court rules. I respectfully move in terms of the motion paper and the supporting affidavit. And
And this review is in respect of our application to reopen our case. And your Lordship's ruling is our first exhibit attached to the application. And in our respectful submission, as our ground A indicates, this ruling was per incuriam section 72 of the Evidence Act 1975 and has occasioned a grave miscarriage of justice. There's no question that in your Lordship's ruling there is no reference whatsoever to section 72 of the Evidence Act. Instead, there's a reference to Black's Law Dictionary, which is an English law text. No reference is made to section 72 of the Evidence Act. Section 72 of the Evidence Act is a statute of Ghana. No reference is made to that, and instead there is a reference made to an English law textbook, which is not what is binding on your Lordships. That is why we say respectfully that that decision was per incuriam section 72 of the Evidence Act. And my lords, the authorities are clear, and we have cited Republic against Tete, which is 2003-2004, Supreme Court of Ghana Law Reports 140, where their lordships in the Supreme Court reversed a unanimous decision that they themselves had given, and they reversed that decision on the basis that they had failed to take into account the Armed Forces regulations, which were part of what their duty was as a court of Ghana. They had failed to take it account. They had failed to take it into account. And so their lordships in Republic against Tete reversed a unanimous decision that they had taken, and they unanimously corrected an error. Now, my lords, in another ruling your lordships have given in this case recently, your lordships have said that even if you did not refer to a certain statute in your judgment, we have not shown that it occasioned a miscarriage of justice. My lords, respectfully, that is fundamental error. Republic and Tete shows that once there is no reference to a statute which is binding on your lordships, we do not need to show further that there is a miscarriage of justice. The failure to apply a statute of the law of Ghana is enough of a miscarriage of justice in accordance with the decision Republic and Tete. And if non-compliance with a statute of Ghana, if that is not a miscarriage of justice, respectfully, I do not know what is a miscarriage of justice. Section 72 is very simple in its terms. Section 72, subject to the discretion of the court in a civil action a party or a person whose relationship to a party makes its interest substantially the same as a party may be called by any adverse party and examined as if on cross-examination at any time during the presentation of evidence by the party calling the witness. Yet, this is what your lordships say in your ruling. At page 5, your lordships say, the question is, how can the chairperson of the first respondent vindicate herself when she is not on trial before us? She has neither been personally sued nor arraigned before this court on any complaint or accusation. for which she has to explain or account to anybody. It is the institution, the Electoral Commission she heads, that has been accused by the petitioner of not having performed his role. Now, my lords, I mean, respectfully, that is not even true. We have respectfully brought the attention of this court, her failure, her singular failure to perform her roles. We do not simply come before this court talking about the first respondent as a commissioner. We specifically have raised issues. The heart of this case is about her declaration. But these are the questions. And then your lordships go on. What indeed baffles this court is the intimation by counsel for the petitioner that he intends to call the chairperson of first respondent as an adverse witness. Black's Law Dictionary defined a hostile witness as so-and-so. There's a whole quotation from Black's Law Dictionary. Then it carries on, in effect, to say that it is only when a witness is in the box that he can be declared a hostile witness. My lord, that is not the law of Ghana. The law of Ghana is not what Black's Law Dictionary is saying, or what their lordships based on Black Law Dictionary are saying. The law of Ghana is what I read from section 72. That says a party may be called. A party may be called. It's not that when they are in the witness box, then they can be turned into a hostile witness. That is not what the statute law of Ghana says. And my lords, it is fundamental and egregious error when on the basis of Black's Law Dictionary, we have the courts of Ghana going against a statute of the land. Ground B of our application, of our grounds. Ground B says that the ruling was in fundamental error in subjecting statutory provisions in the Evidence Act to the provisions of subsidiary legislation. My lords, there again, nothing could be more basic. Nothing could be more basic than the fact that a statute is superior to subsidiary legislation. The Rules of Court Committee are not of a higher standing than the Parliament of Ghana. And so when you have a judicial decision of the highest court of the land effectively subjecting Parliament's law to the Rules of Court Committee, that is fundamental.
Mr. Chikata.
Yes.
Are you suggesting that CIs do not go to Parliament?
CIs go to Parliament, but they go to Parliament in a different way from how statutes go to Parliament. That is why the Constitution makes a distinction between the exercise of powers by people such as the Electoral Commission who take the CIs to Parliament, and if there's no objection, it goes through. That is a different process from a statute, which is an act of Parliament which overrides subsidiary legislation. My lords, there can't be any question. And if your lordships have an issue with that, I'm afraid that that is just fundamental error. There can't be any question that subsidiary legislation, such as is contained in a constitutional instrument that brings into effect what the rules of court have done, there can't be any question that those are subordinate to the Evidence Act. There can't be any question about that. So where in your ruling your lordship say that you're not going to apply the Evidence Act because there is a rule of court, and that rule...
Isn't that the exercise of our discretion which prefaces the section that you read?
My Lord, those are not the terms of the ruling. The terms of the ruling that your lordships gave, the terms of your ruling are very clear. And unless the ruling is being rewritten, the terms are very clear. Namely that the evidence section 20, we wish to state that, this is at page 10 of the ruling, we wish to state emphatically that section 26 of the Evidence Act, which is on conclusive presumption, is not applicable in this case in view of Order 38, Rule 3E5. That is what the ruling says. It doesn't say that in the exercise of my discretion, this and that. It doesn't say that. It just says it is not applicable. That is what it says. Nothing more, nothing less.
Mr. Chikata?
Yes.
Do you have the list of everything that the panel took into account before coming to that conclusion?
It is a ruling of the panel that we are here to question. And the ruling in its terms is what is before us. Obviously, I'm not in the minds of the panel, and I'm not able to divine whatever went on in their minds, except my reference to the terms of the ruling. And my lords, in any event, Order 38, Rule 3E5 has nothing whatsoever to do with the application of the Evidence Act, Section 26. Order 38, 3E5. It reads as follows, that is as amended by CR 87. If a party who has served a witness statement does not call the witness to give evidence at the trial or put the witness statement in as hearsay evidence, any other party may put the witness statement in as hearsay evidence. That provision has nothing to do with the Section 26, which the court was stating emphatically is not applicable because of this order. The terms of this order are themselves very clear. They do not have anything to do with what Section 26 says. What Section 26 says is, again, not controversial. What Section 26 of the Evidence Act says is simply establishing a conclusive presumption in a circumstance where somebody has put before the court clear indications by way of affidavits that she will be available to be cross-examined. That leads to what Section 26 describes as a conclusive presumption based on the estoppel by own statement in Section 26, except as otherwise provided by law, including a rule of equity, when a party has by his own statement, act, or omission intentionally and deliberately caused or permitted another person to believe a thing to be true and to act upon such belief, the truth of that thing shall be conclusively presumed against that party or his successors in interest in any proceedings between that party or his successors in interest, and such relying person or his successors in interest. Order 38, 3E5 has no relevance in terms of that. And our submission is simply that the court cannot sideline the operation of a statute by reference to subsidiary legislation, which in any case has no relevance to the issue of Section 26. My lords, we indicate in ground C, in ground D, so we've dealt with A, B, and C. We indicate in ground D, we take B and C together. And I argued in relation to B and C that the fundamental errors consist of sidelining legislation in favor of subsidiary legislation, and in relation to ground C, sidelining it in favor of subsidiary legislation which is irrelevant to the issue in the statute anyway. And so we move to ground D. And in ground D, our submission is that here again, the court made no reference whatsoever to Order 38, Rule 10 of CI 47, nor indeed Section 58 of the Courts Act. And Section 58 of the Courts Act is a section which even gives power to your lordships to call a witness. And that section has been properly applied. So in other words, apart from our ability to subpoena upon reopening of our case, apart from that, there is also the opportunity for this court itself to call a witness. And the circumstances in which the court does that, those circumstances are exemplified in the case of Wardier and Bukhari. Wardier and Bukhari, 1976, 2 Ghana Law Reports, 371, where the Court of Appeal, the then Apex Court, proceeded as follows. And this is from the judgment of Justice of Appeal Archer, as he then was. After judgment had been reserved in this court, it was felt that this court should not be placed in the same situation in which the court below found itself. It was therefore decided to ascertain the truth in this matter, and so on. And based on that, the court had recourse to the Courts Act to ascertain the truth of the matter. And then the court went on to point out that just that invitation of the witness to come and testify had brought up a very important piece of evidence, which, if it had been adduced in the court below, would have spared that court the torment of exploring whether or not the certified true copy of the plan from the Lands Department was the plan tendered before Jackson J. And the court even goes on to say, one can understand Mr. Joe Rindolph's initial reservations, but as this additional evidence has enabled this court to ascertain the truth beyond all doubt, we think by allowing this additional evidence to be admitted, Mr. Rindolph conducted himself in the best traditions of the bar. Indeed, those words in respect of the best traditions of the bar evoke some nostalgia in the hearts of some of us. And my lords, we are respectfully saying that the ruling that your lordships gave did not even advert to Order 38, Rule 10, which we had indicated was the basis on which we were seeking to reopen our case. It didn't even advert to that, and it was therefore per incuriam. We say also in ground E, which I move on to now, that the ruling was per incuriam Article 1913 of the Constitution and has occasioned a grave miscarriage of justice. And Article 1913 is the provisions on the right to a fair trial in this court. And we show in our submissions on that matter how this Supreme Court adverted its mind to a decision of the Supreme Court of the Netherlands, in which the Supreme Court of the Netherlands was highlighting the importance of ascertaining the truth in matters that were before it. And that was made to displace, in the interest of the right to a fair trial, it was made to displace even international relationships as being something that the court would have reference to. That decision in the case of Chatuchikata and the Republic is a decision that we have cited in our submissions, and I will not go further into that, except to underline the fact that the Supreme Court of the Netherlands, whose reasoning was adopted by the Supreme Court of Ghana, also considered it appropriate that in the interest of ascertaining the truth, it was of value to the court to call a witness.
Once again, I'm curious about something. If it was so important to you to have a particular person testify for you, why did you not present that as part of your pre-trial positions?
My lords, we could not, for the reason that I've given a few times in this court. At the time, that first respondent's chairperson was the person who had filed a witness statement on behalf of, well, first of all, had filed an affidavit of verification of the case of the first respondent. Subsequently filed a witness statement on behalf of the first respondent. And my lords,
so in essence, you were hoping to rely on her coming to testify and found yourself without that. And that is why now you are asking that she comes as your witness after everyone has closed their case.
My lords,
is that what you're saying in essence?
My lords, what we're asking is for our case, for us to have leave to reopen our case. That witness, as we've indicated, had sworn affidavits in response to our application for interrogatories, in response to our application for stay in relation to that. And in those, she had given every indication that she would testify. We had no reason to believe that she wasn't telling the truth. We had no reason to believe that she didn't mean it when she swore those affidavits. We had no reason to believe that anybody in the court would have assumed other than that she would testify. In fact, the day that it was announced that she would not testify, on that day, your lordship themselves expressed, some surprise, and that was the reason why you adjourned to the next day for arguments to be raised and so on. So, my lords,
Mr. Tikata, when you announced that you had closed your case, what did you mean?
Nothing more, nothing less. We had closed our case. And when we announced that we are seeking to reopen our case, I mean exactly that, nothing more, nothing less. We are seeking leave to reopen our case in circumstances where a person who has deposed to affidavit saying she will be available for cross-examination, and where your ladyship specifically had intimated that the questions that we're seeking to raise in interrogatories could be asked of her in cross-examination. I'm sure your ladyship has not forgotten that bridge. And in that context, your ladyship had said that aren't we crossing a bridge that we have not got to? And we indicated that at the stage of interrogatories, we still found it appropriate to anticipate that. But your ladyship said the bridge will be there. That bridge is no longer there.
When you said that you had closed your case and you meant it, nothing more, nothing less, what did you mean?
I really don't understand what more your ladyship wants by way of an answer. We meant that we had closed our case. And we had closed our case, and subsequently we sought leave to reopen our case. Your ladyship cannot say that we are not able, under the rules, under your inherent jurisdiction, to ask for your leave to reopen your case. I don't believe that that is a suggestion that your ladyship is making.
I don't think I've said any such thing.
So but it's very difficult to comprehend.
I just wanted to understand what you meant when you said you have
I've answered that question, I think, twice or thrice already.
Nothing less. And I'm satisfied with the answer, sir.
My lords, we continue finally to the last ground, that the ruling was in breach of Article 296. And my lord, very simply put, what we're saying is that that ruling is completely unreasonable in terms of in terms of what are often referred to as the Wednesbury principles. And her ladyship, Justice Georgina Wood, as she then was, in the case of TDC and Musa against Atab Balfour, 2005-2006 Supreme Court Law Reports, page 121. Her ladyship, at page 131, expressed the specific terms of what such unreasonableness amounted to. And by saying that he, that is the plaintiff in this case, succeeded in showing that the case fell within the irrationality or unreasonable rule, in that the decision arrived at by the TDC defies logic and common sense or accepted moral standards, and that without meaning any disrespect to the TDC, no sensible or reasonable person called upon to apply his or her mind to the decision to be taken could have come to that decision. In short, the decision to throw him out of the house and foist a residential plot on him is irrational and unreasonable. And we are saying respectfully that your lordships, in the exercise of your discretionary powers, unfortunately failed to advert your minds to relevant statutes, introduced irrelevant considerations which prejudiced a fair exercise of discretion as required by Article 296 of the Constitution. It is our submission that holding the first respondent, and particularly his chairperson, accountable for the exercise of powers conferred by the Constitution and statute justify, in the circumstances of this case, that that chairperson be called upon to testify using the time-tested subpoena procedure that we seek to invoke in this case. My lords, there is no question that the process of review is among the ways in which corrections are made by your lordships. And as Aqua...
Your time is up.
May I just finish in a minute, because I'm in the middle of a sentence. Is that allowed?
Okay. You may finish.
As Aqua indicated in the Koglex case, heeding the promptings of conscience, as he put it, heeding fidelity to the judicial oath, he found it appropriate to reverse a decision of the ordinary bench. May each of your lordships decide in accordance with your conscience and your judicial oath. Ultimately, and even more profoundly, it is for the chairperson of the first respondent to come forward to testify as she indicated on oath she would do. I conclude with prophetic words that were spoken centuries ago. For they sow the wind, and they shall reap the whirlwind. These are the words of the prophet Hosea, to be found in Hosea chapter 8, verse 7. He that has an ear, let him hear.
Order in court, please. Order.
Yes. My lords, we are vehemently opposed to this application for review number 3. Lord, we have filed an affidavit in opposition as well as a statement of case, and we rely on it. Lord, under Article 33(1) of the Constitution, this court may review 133(1), my lords, 133(1) of the Constitution. This court may review any decision made or given by it on such grounds and subject to such conditions as may be prescribed by the rules of court. Also, even the Constitution recognizes the role that is played by the Rules of Court Committee. And indeed, my lords, the Rules of Court Committee passed the Supreme Court Rules 1996 CI 16. And lords, the specific rule on review is Rule 54. Lords, this court is the final court of the land. We concede that the court is not infallible. But, my lord, your lordships may change your mind in an application for review only when certain conditionalities have been met. My lords, those conditionalities have been set out in Arta number 2 versus Arta number 2, 2013-2014, 1 Supreme Court of Ghana Law Reports, 569, at pages 579 to 580. Lords, I will not read those conditionalities there, but they are there. Lord, it's only when those conditionalities have been met that the review panel should seriously consider the merits of the application. Lord's submission that the conditionalities set in Rule 54 of CI 16 and ATA have not been met by the applicant in this application. Lords, with the greatest respect, the grounds are basically an academic treatise of alleged erroneous pronouncements made by your lordship panel of 7. Indeed, if we want to give some credit to the grounds, my lords, they are at best additional grounds that have been filed without leave of your court in terms of an appeal, but they do not form grounds for review for which my lords should grant this application. My lords, may I refer your lordships to the ruling that has generated this review at pages 11. With your kind permission, your lordships held, accordingly, in weighing the propriety of reopening proceedings to permit new or additional evidence to be led or tendered, the court will typically consider the following broad questions. 1, will the evidence, if it had been presented during the trial, have had any influence on the result? 2, could the evidence have been obtained before or during trial by the exercise of due diligence? Then your lordship conclude that thus, in this application, the petitioner has not given us an inkling of the new or fresh evidence he wants to bring to the fore. Neither has he disclosed how that evidence would advance the cause of his petition. Lord, I believe that this is the crux, this is the ruling that the court made. And in the absence of any attack or any submissions regarding this application must fail. Lord, I say further, I submit further, that the grounds are very misconceived and have no bearing at all on your ratio that I've set out above. Even as submissions were made by the counsel for the applicant, and even as I'm speaking, still, my lords, the court is still not aware, it still doesn't have the inkling of the evidence that the applicant wants to lead, for which the case should be reopened. Lord, this leads me to the Wardier case that was cited by counsel for the applicant. Because in that case, the evidence was known. The evidence was that there was an issue about Exhibit A. And by agreement of counsel, the court then said that let an expert come and testify as to the authenticity of the document. So in that case, the court allowed further evidence just because the evidence that the expert was being called was known. This is not the situation in this case. Lord, what has been done is that there has been arguments that border on the nature of an appeal. Indeed, if my lords look at paragraph 3 of the affidavit in support, with your kind permission, if I may read, he says that at the hearing of this application, I shall, through my counsel, seek leave of this honorable court to refer to all processes filed in this case up to the date of the hearing of this application, clearly indicating to your lordships that he is going to argue an appeal. And that is why your lordships...
It is an application based on previous processes.
Yes.
You see, so in motions,
yes,
what you try to do is that instead of seeking leave when you are on your feet, to refer to it,
yes,
you can capture it in the affidavit.
Yes.
So don't ask for this one.
No, my lord, if my lord could hear me on the point I seek to make is that as a result of that, the submissions that were, for example, dealt with on the 18th have been brought in. For example, section 26 of the Evidence Act was dealt with. That's the point I seek to make by referring to this submission. My lords, this court has said time without number that the review jurisdiction is not an opportunity given to a party to come and argue the case again as if the review panel is sitting in judgment on appeal over the ordinary panel. And this is what my learned friend has sought to do. Lords, may I crave your indulgence to refer to the Standard Bank Offshore Trust Company Limited versus National Investment Bank. Lords, in civil motion number J7/15/2017. Lords, Doche JSC, delivering the ruling of the court, admonished sore losers at page 17 of the judgment thus: from the ratio, with your kind permission, from the ratio of the decided cases of this court on review, it is immaterial if the applicant for a review considers the decision of the ordinary court to be wrong in law or has an emotional reaction to it, as in this case, the magnitude of the amounts involved or the shutting of the door to applicants because of the effluxion of time in instituting a fresh action. These are not factors that a review bench normally takes into consideration, my lords. Lords, in that case too, the court went on and held that the rules of the court forms an integral part of the laws of Ghana, and consequently, they must be given an equal amount of respect in order to produce the sanctity in court proceedings.
Mr. Menuvo,
Yes, sir.
are you referring to me as a sore loser? I argued that application for review before this court. I was standing where you were some few years ago, and I lost that application.
Well, my lords, the review panel forms that view of you. The review panel forms that view of you, my lord, and indeed of your client, my lords. My lords, incidentally, my learned friend was on the other side in that matter, and he got the review. Yes. My lords, the case of Mechanical Lloyd Limited versus Nati again is there on the point. Lords, arguments have been made in this court regarding fair trial. My lords, I ask just a couple of questions of the petitioner. This petition, my lords, has been conducted in a piecemeal fashion, which is one of the things that CI 99 deprecates. First, orders of the court are disobeyed, file, witness statement no. You yourself intimate that I'm going to call 5 witnesses. You call 2. And then you come back to the court, oh, my lord, I forgot one person, permit me. It is permitted. You call that person. Yes, my lord. Oh, my lords, this is the issue of fair trial. My lords, with the greatest respect, the issue of fair trial has been raised. And now I'm saying that he has been given fair trial in the way the case has been conducted, my lord. Lord, then we go from there to having called the 3rd witness. What is your pleasure? Oh, my lords, I close my case of your own volition. Lord, it is my submission, therefore, that the petitioner was given every opportunity. He was fairly heard in these proceedings. And what has been filed, review number 3, is an abuse of the court processes, and the application ought to be dismissed in limine.
Mr. Menuvo, you have not addressed us on the reference to Hosea, the gospel according to Hosea. Yeah.
My lords, I made
order, please.
My lords, my point I wish to make on that, if you permit me, is that God is a God of conscience, and God does not use court processes to elicit conscience. No. God is a cause of conscience, and therefore you do not bring God into the courtroom to now claim that because of God, application should be granted. That's my response.
Isakutampa.
Yes,
30 minutes.
My lords, we are opposed to this application, and my lords, we rely upon affidavits in opposition filed on the 21st of February, together with our statement of case. My lords, our first submission is that this application woefully fails to satisfy the conditions for the grant of a review application. As in our view, it does not demonstrate any fundamental error committed by the court which has occasioned the petitioner miscarriage of justice. And on that ground alone, this application ought to be dismissed summarily. My lords, now on ground A of petitioner's application, the petitioner refers to section 72 of the Evidence Act. Now, my lord, section 72 of the Evidence Act reads thus. 72 sub 1. Subject to the discretion of the court, in a civil action, a party or person whose relationship to a party makes its interest substantially the same as a party may be called by any adverse party and examined as if on cross-examination at any time during the presentation of evidence. At any time, my lords, during the presentation of evidence by the party calling the witness. My lord, it is very significant that in his statement of case, there is a deliberate omission of the controlling word evidence by the party of evidence. That is, and I see no reason to believe that this was inadvertent, because it is repeated twice. And on both occasions, this critical word is left out of evidence. Now, what is the significance of adding of evidence, reading section 72(1), including of evidence? It means that a party can only exercise that right when he has not closed his case. That's what it means. And I want to repeat this. Section 72, which appears to ground the backbone of this application, relates to a situation where a party has not closed its case. Now, in this instant situation, the party had closed its case. So the court had no business referring to section 72(1) because it was irrelevant to the circumstances of the case. And my lords, it is my submission that knowing that they have closed their case, the petitioner disingenuously omitted of evidence. And with all due respect, this is highly improper. So, my lords, all the submissions around section 72 that the court was per incuriam of section 72 are totally unmeritorious and irrelevant. Now, my lords, we proceed to deal with grounds B and C. And my lords, counsel for petitioner has argued that Order 38, Rule 3E, 5 cannot override Section 26 of the Evidence Act, because in his view, the Evidence Act is a substantive legislation, and Order 36 is subsidiary. My lords, 38, sorry, is subsidiary. My lords, it may well be the case that Order 38, Rule 3E5 is a subsidiary legislation. But the point here, the critical point here, is that the very principal act, this is the Evidence Act, Section 26, by itself delimits the application of the main text by the words subject to a rule of law or equity. And my lords, there can be absolutely no doubt that Order 38, Rule 35, is part of the laws of Ghana. So it is because of the specific provisions of Section 26 that the court could then look at Order 38, Rule 3E5 and rely upon it in making its ruling. So, my lords, respectfully, I think it is misconceived to suggest that in doing so, the court had committed a fundamental error by allowing a subsidiary legislation to trump a substantive act of Parliament. My lords, we would next address Rule Ground C, which relates to Act 459, Section 58. Ground D. My lords, in my respectful view, Section 58 of Act 459 is completely irrelevant to the matters before the court. Because the matters before this court, which is the subject matter of the review application, relate to the court's decision not to reopen the case. My lord, that is the decision of the court. Now, Section 58 reads, in any proceedings and at any stage of the proceedings, a court, either on its own motion or on the application of any party, may summon any person to attend to give evidence or to produce any other document. My lord, this provision presupposes that the party who is applying to summon another has not closed its case. Now, this is obvious common sense. It is very clear that this provision cannot relate to a situation where a party has closed its case. And my lord, these are the ways in which provisions of the law have been persistently cited out of context. Perhaps to mislead those who do not know the law. So, my lord, it is our respectful submission that a reference to Section 58 of the Evidence Act, of the Courts Act, in this situation is totally misconceived and should never have been made by counsel. My Lord, we wish also to make the point here, for the last time, that the chair of the first respondent has never made any undertaking that she would mount the witness box, such that the petitioner could claim that he relied on it to his detriment. My lords, all that the chair of the first respondent did was to repeat what the law is. That is all that he did. The law, and if your lordships go to order 22, rule order 22, all that the chair of the first respondent did was to repeat the position of the law, which is that if you fail to obtain interrogatories in relation to a matter, you may, during cross-examination, elicit the same information. That is all. It was never an undertaking. And it beggars belief that the petitioner and counsel are basing this statement of the law as an affidavit, an admission or a representation that they relied upon to their detriment. My Lord, I therefore wish to submit that a reference to the deposition of the first respondent's chair on this matter can never constitute an estoppel, because she has the right to refuse not to enter the witness box. And the court has ruled definitively on this. This application for review of the decision to reopen cannot be the back door through which that earlier ruling can be considered. The court has ruled on it, and that ruling binds all of us, including counsel for the petitioner. My Lords, the fair hearing argument, my Lords.
There are 5 minutes more.
Very well. My Lord, I thought I had a lot more minutes. Unless your Lordship thinks I've made out my case, so...
You have 5. Out of the 30, you have 5 minutes more.
My Lord, ground E relates to the allegation of breach of his right to fair hearing. My Lord, the right to fair hearing is a right that all parties to a suit are entitled to. So, the court has ruled that the respondents have the right to elect not to adduce evidence. That is their right under the law. Therefore, to seek to reopen your case so that you can compel the first respondent through his chair to enter the box It's a breach of the first respondent's right to fair hearing also. My Lord, it's our considered view that no evidence or analysis has been made by counsel for petitioner that sustains their claim that their right to fair hearing has been breached. Indeed, this court has been more than accommodating to the first, the petitioner. They defied the court's order with impunity not to file witness statements at the time they were ordered to. They have even again defied the court's order to file closing addresses. And perhaps the court may once again accommodate their defiance of the highest court of this land. And then they turn around to talk about fair hearing. In our respectful view, their case should have been struck out when they failed to file their witness statements as ordered by the court. Or it could have been struck out. And as we speak now, since they have defied once more to file their closing address, this case can be settled without their closing address, and it will be fair trial. My Lord, I'm saying it will be fair trial for that to happen. Possibly, the court is once again going to accommodate them. So they should be the last people to be mounting the high horse and talking about breach of their right to fair trial. My Lord, our respectful submission is that this allegation of breach of their right to fair trial is an invitation to the court to go on a frolic which has absolutely nothing to do with the issues before this honorable court as to whether any person, any of the two parties, the petitioner or the second respondent, obtain more than 50% of the valid votes cast in the 2020 elections, presidential elections. My Lord, again, the reference to 296 is in our view quite surprising. Yes, my lords, the court was right in the TDC case to hold that the acts complained of were unreasonable and irrational. But my lords, in the instant application before your lordships, the petitioner has failed once again very badly to demonstrate the facts which ground the allegations of unreasonableness or irrationality. Because those facts, my lord, are based on the grounds that he has dealt with earlier on, A, B, C, D, which we have demonstrated to be hollow and of no merit. Accordingly, my lords, we believe that, and we submit that the application is devoid of merit. It is deserving of a summary dismissal, and given the fact that the arguments are only a rehash of earlier arguments and the introduction of irrelevant provisions for the consideration of this court, we pray that in this exceptional situation, this application be dismissed as an abuse of process. will be dismissed as an abuse of process and costs, punitive costs,
Your time is up.
multed. And Lord, we are done.
My Lord, may I, with your leave, make a couple of brief references. My learned friend for the second respondent, I heard him a little while ago say that we are acting in breach of the right of the chairperson of the first respondent as far as testifying is concerned, as far as our indication that we are seeking to subpoena is concerned. And my Lord, as a matter of law, respectfully, it is not for the second respondent to bring up a witness's claim to immunity, whether on the basis of a right to fair hearing or self-incrimination or whatever. It is not for the counsel for the second respondent to bring up a witness's claim to immunity. The witness must themselves, that witness must, his or herself, I should say, his or herself, put forward whatever claims she seeks to make to immunity. And my Lord, I believe that that was the reason for our reference to the case concerning the IFC's immunity and so on. And my Lord, counsel for the second respondent also sought to suggest that I had somehow sought to mislead the court in terms of section 72. Well, that's a very serious insinuation. Well, it's not actually an insinuation. It was a very express statement on his part. And my Lord, I can only say that counsel is obviously not clear about the nature of the application that is before you. Because the nature of the application that is before your lordships is to seek to reopen our case for the presentation of evidence. That's the nature of the application that is before you. So reading section 72 about the presentation of evidence and making it seem as if what we are doing is somehow foreclosed because we have closed our case just shows that he hasn't understood why we're in court this morning. Because, my lords, we're in court asking your lordships to reopen our case so that we can go according to certain processes. That's what we're in court for. So for him to be saying that we are trying to mislead you by not referring to during the presentation of our case and so on, my lord, that is just a clear failure to appreciate the terms of section 72. And my lord, he completely does not address the point that we make, that section 72 was not even referred to by your lordships, and that your lordship's ruling is per incurium of that section.
Are you done?
Yes, I'm done.
Yes, I have one question for you.
Yes.
Your arguments, you dwell mostly on section 26. Section 26 of the Evidence Act. Can you show me any conflict between section 26 and order 38? Is there any conflict between section 26 and order 38, 38 rule 3 E5? Is there any conflict?
My lords, I was referring to the fact that the ruling implies that there's a conflict, and that in the ruling it says this section is not applicable because of order 38.3e. And my lords will notice that I in fact went on to argue. I argued that rule 38.3e5 in fact has nothing to do with section 26. Your lordship will recall that I argued that. So I was specifically referring to what was in the ruling. The terms of the ruling are clear.
So it was not a matter of the court preferring subsidiary legislation to a substantive
that's what the court said. I mean, I read it. The court said.
No, we didn't say so.
We wish to state emphatically that Section 26 of the Evidence Act, which is on conclusive presumption, is not applicable in this case in view of Order 38.
But it doesn't mean that the court was preferring or raising Order 38, raising 38 against above Section 26. That is not what we meant.
Well, my lords, I leave that to your lordships, but the language of the ruling is what I'm referring to. But I leave it entirely to your lordships. The language is that it is not applicable in view of something else. So that other thing is being made applicable, whereas Section 26 is not being made applicable. I mean, there's no running away from that. If you say this is not applicable in view of this, then it means that what is you say is applicable.
Yeah. No.
You're setting aside.
That is what I'm not. It doesn't make it superior to Section 26.
Yeah, but my lord, how can your lordship say that Section 26 is not applicable in view of Order 38?
That is our view.
Yes, but my lords, and that was the other point I was going to make, respectfully, and I'm glad that it has come up. Reference has been made to your ruling in respect of another application in which you did seek to consider Section 26. And there we argued that no reference had been made. It was per incuriam Section 26. In that ruling, again, no reference was made to Section 26 at all. In your ruling in that case, your lordship said, effectively, yes, we didn't make reference to that Section 26, but we haven't been shown that a miscarriage of justice has arisen because we didn't make reference to it. And my respectful submission is that, and I did say so, that is itself fundamental error. And your lordship should take the opportunity to correct that error because you didn't make reference to Section 26, and you sought to justify that by saying that no miscarriage of justice has been shown to you. And my submission was that when you don't apply a statute, there's no reason for miscarriage of justice to be a further ground.
Different from,
I'm sorry.
When you don't make a reference, it's different from not applying.
Well, my lord, if you don't even make a reference, you can't apply. I mean, if you don't even make a reference to it, you can't apply it. I mean, you make a reference to Black's Law Dictionary. Black's Law Dictionary, you make a reference to that. Black's Law Dictionary is not binding on this court. It's stating common law rules which have been changed by statute in this court. But you make reference to Black's Law Dictionary. But you don't make reference to the statute that is binding on you. Well, that is per incuriam. That's
no. That is your opinion.
Well, that is indeed my opinion, and I think it's backed by a plethora of authorities of this court.
The court will rise to consider his ruling.
all rise.
welcome back to our studios here at the GTV Broadcasting House here in Kanda. You just heard the arguments coming from the petitioner and from the first and second respondent. The petitioner arguing why a review should be given to that ruling on the 16th of February, which the courts said that they will not allow the petitioner to reopen their case. So the petitioner this time around had to argue out a review of that particular judgment. The first and second respondent argued against that particular review. As of now, the court move into its chambers to decide on whether to grant that kind of review or not to grant that review. And realize that because it's a review application, you had 9 justices sitting to determine the review, unlike the 7 for the main case itself.
Right. And also, Judge, today, I mean, if the plans of the courts, go through, then we are expecting to hear the date for the final ruling. That's if nothing changes. That's the indication we have. But let me just take our viewers through the grounds upon which the petitioner is seeking a review of the 16th February ruling. And the first ground is that the ruling of the courts was per incurium, Section 75 of the Evidence Act 1975, NRCD 323, and has occasioned a grave miscarriage of justice to the applicant. And so we have Dr. Budu, who is on the standby. You give us an understanding of some of these constitutional provisions and what they mean. The second ground is that the ruling of the court was in fundamental error in subjecting statutory provisions in the Evidence Act 1975 of the provisions of subsidiary legislation, specifically Order 38 Rule 3A5 of CI 47 as amended by CI 87, and has occasioned a grave miscarriage of justice to the applicant. The ground C says that the court fundamentally erred in its interpretation of Order 38 Rule 3E5 of CI 47 as amended by CI 87. D, the ruling of the court was per incurium, Order 38 Rule E of CI 47 and Section 58 of the Court Act 1993. Let me do E. The ruling of the court was per incurium, Article 19(3) of the Constitution, and has occasioned a grave miscarriage of justice to the applicant.
All right, so we have Dr. Kwekwajiman Budu, who is a lawyer, is a law lecturer, the head of Law Center's Gimba Faculty of Law, and also the founder and executive director of the Justice Foundation. Doc, we're back. Good morning once again, and let's take us through some of the presentations, from the 3 sides, then we can move into other areas too.
Oh, okay. So basically, as you rightly summarized, this morning's proceedings have been in relation to an application that was brought by the petitioner, basically seeking the court to review its decision or its ruling that it gave on 16th February in relation to the application to reopen their case. Remember that the petitioner had closed its case and the respondent also closed their case, and we saw an objection which was in relation to the earlier ruling which we talked about earlier on, the fact that the respondents had closed their case, but afterwards the petitioner also filed an application seeking to reopen their own case, to issue a subpoena to compel the Electoral Commission chairperson to testify, and that application was not granted, and so that is the basis for this review application today. So as you rightly pointed out, the petitioner is seeking a review of that ruling of 16 February on 6 main grounds. And earlier on, before we went for the proceedings, you were asking, I think Morris was asking about Article 133 and Rule 56. Sure. And Article 133 of the Constitution, yes, basically provides the review jurisdiction of the Supreme Court and gives them the power to review any decision that they have made or given on such grounds and on such conditions as the Rules of Court Committee will prescribe. And the Rules of Court Committee is that committee under the Constitution that has been given the mandate to prescribe rules of procedure that must be followed in our various courts. And they exercise that power to enact, if you may, the Supreme Court Rules of 1996, CI 16, which provides for 2 grounds of review in Rule 54. The first ground, which is what the petitioner is coming under, is that there are exceptional circumstances which have resulted or occasioned the miscarriage of justice. The second ground that a petitioner can come on for a review is that they had discovered or have discovered new and important matter or evidence which, after the exercise of due diligence, was not within their knowledge or could not have been produced by him during the time the earlier decision was given. So that's Rule 54. But Rule 56, which the applicants base the application on, which I believe that's why you were asking, is a rule that provides for the procedure and requirements that you must comply with when you're bringing an application for review. So basically, it has to be by a motion which is supported by an affidavit and accompanied by a statement of the applicant's case, which will clearly set out and fully argue all the relevant grounds on which the applicant is relying for the purposes of the application. So that is why we see Rule 56 being cited by the applicant, because they are complying with that particular rule in the sense that they filed a motion for the review that was accompanied by an affidavit deposed to by the petitioner, and also they had a statement of case in which they argued those 6 grounds which you talked about, which you set out for our viewers, which relates to exceptional circumstances occasioning a miscarriage of justice. So that is basically the preliminary points in this whole discussion.
All right, so one of the so the petitioner says that the Supreme Court didn't make reference to Section 72 of the Evidence Act, and you realize that both the petitioner and the First Respondents Council have, in a way, read that same section to us in different forms. Can you just take us through Section 72 and help us understand some interpretation from the academic point?
So basically, that is the first ground for review of the applicant's petitioner. So that ground, as you rightly stated, was that the ruling of 16 February was per incurium. Per incurium meaning the ruling did not have due regard or did not have regard for Section 72 of the Evidence Act, and as a result occasioned a miscarriage of justice, on the petitioner. So what does Section 72 say? I wanted to project Section 72 so viewers will be able to follow through, but I don't think screen sharing has been enabled. So if subsequently it can be enabled, it will make it much clearer as we go through the discussion.
Right.
But basically, Section 72 provides, and permits me to read slowly so that we follow.
Sure.
It provides that subject to the discretion of the courts, in a civil action, a party or a person whose relationship to a party makes the interest of that person substantially the same as a party, may be called by an adverse party and examined as if on cross-examination at any time during the presentation of evidence by the party calling the witness. So that's what Section 72 says.
Sure.
And the petitioner is therefore arguing that by virtue of the fact that the court in its ruling on 16 February only referenced the Black's Law Dictionary's definition of adverse or hostile witness, without adverting its mind to Section 72 of the Evidence Act. To that extent, the petitioner believes that the court erred because, according to the petitioner, the law of Ghana on adverse witnesses is provided for by that provision, that is section 72 of NRCD 323, and not the Black's Law Dictionary, which is not applicable in Ghana, which basically only states a common law position, which according to the petitioner is not that which is controlling in Ghana by virtue of section 72. Which means we need to remind ourselves what the court actually said in that ruling in relation to that particular issue of adverse witness. And this is what the court said. And once again, you permit me to read it out so that we set it out in context.
Sure.
The court said in part that, and I asked this question to begin with, does the petition need the personal testimony of the chairperson of the institution sued before he could prove or establish the alleged non-performance of this constitutional duty by the first respondent? We do not think so. What indeed baffles this court is the intimation by counsel for the petitioner that he intends to call the chairperson of the first respondent as an adverse witness. Black's Law Dictionary, 9th edition, edited by Brian A. Garner, defined a hostile witness as, quote, a witness who is biased against the examining party, who is unwilling to testify, or who is identified with an adverse party, also termed adverse witness, end quote. A hostile or adverse witness, as the definition shows, and as we understand the term in practice, is therefore a witness who has been called by a party to testify in support of his or her case, and who, whilst in the witness box and the examination in chief, becomes hostile and gives evidence contrary to the party who called him and in support of his opponent's case. The party, in such circumstances, can apply to the court to treat such a witness who is already in the witness box as a hostile or adverse witness.
Right.
This would enable the party calling him to cross-examine him as if he is a witness of his opponent to solicit the truth in respect of the issue at stake. A witness who has not yet entered the witness box to testify cannot therefore be called an adverse or hostile witness under any circumstances.
Right.
And that was the ruling of the court in relation to that particular issue. So the first point that we need to understand is that the Evidence Act, the NRCD 323, captions section 72, which I read out earlier. It captions it as follows, that adverse witness in a civil action.
Okay.
But if you read the provision carefully, it does not necessarily define an adverse witness. What it rather does is to give the court the discretion, which simply means discretion means that the court has the power to decide one way or the other. So it's not automatic that the court has to decide one way. The court exercises a discretion to either decide one way or the other. So it gives the court that power to decide one way or the other, whether to enable a party in a civil suit, say a plaintiff, to call another party in that suit, say the defendant, or the plaintiff is also given the power, for instance, to call a person whose interest may be the same as, say, the defendant, at any time during the presentation of evidence by the party calling that witness. That is the plaintiff, who, when they are producing their evidence, they are giving their evidence, calling their witnesses, they have that option to call the other party or a witness whose interest may be in line with that other party so that they cross-examine him. But this is subject to the discretion of the court. And right. So it's not automatic. So such persons, for instance, may include persons whose testimony may be in favor of that other party. So for instance, your adversary. So it could be a spouse. So if you are seeking to call the spouse of the person that you have sued, it's sometimes assumed or presumed that the spouse of the parties, his interest or her interest may be in line with that other party, so he or she may not necessarily be favorable to you. That's why sometimes they are referred to as unfavorable witness or hostile witness and things of that sort. So the petitioner is basically saying that the court, in not adverting its mind to Section 72 of the Evidence Decree, or the Evidence Act as it's now referred to, but rather relied on the Black's Law definition of adverse witness, had committed a fundamental error of law, and as a result, a grave miscarriage of justice had been occasioned by the court. That is the argument of the petitioner in relation to the first ground.
Right. So, counsel for the first respondent has argued that the Section 72 is applicable only at the presentation of evidence stage. So, at that point where the petitioner was seeking to reopen their case, and can we say that they were it amounted to presenting fresh evidence, and so they were still at the presentation of evidence stage?
So at this stage, what we know for certain is that all parties in this suit have closed their case, their respective cases. And what the petitioner is now seeking to do is to reopen his case. And in reopening his case, all that the petitioner is seeking to do is to introduce new evidence. That is a fact. The court said that in its last ruling. The ruling that is being, that the application is in relation to seeking the review. The court stated clearly that the grounds or the circumstances that the court will consider when exercising its discretion to allow a party who has closed his case to reopen his case are similar or are essentially the same as those circumstances that the court will have to consider when a party seeks to lead fresh evidence. Because essentially, if you are granted that opportunity to or leave to reopen your case, you will be seeking to lead evidence. And the petitioner has not made this, or has made this clear, that the purpose for seeking to reopen their case is to subpoena the chairperson of the Electoral Commission to testify, and there will be evidence in that regard. So he's seeking to lead evidence in that regard. But as of now, their case is closed. So they're only seeking to reopen it to lead evidence. And the respondent is saying that on the basis, or the second respondent at least, is saying that on the basis of the provisions of Section 72, that's why I was saying that if your technicians could grant me access to share the screen, I could be able to share the provision so that viewers are able to actually follow it.
All right.
Yes, because when we're saying it, sometimes it goes a little fast. So if they see it, they'll be able to appreciate it. So Section 72 is saying first and foremost that that provision which allows a party to call another party or a person whose interest may be adverse to the person calling that other person to be treated as an adverse witness, that provision is subject first and foremost to the discretion of the court, which means it is not automatic. So that's the first thing.
Right.
The second thing, what the respondent is saying is that if you read the provision carefully, it also says that this can apply at any time. Those are the last words of the provision. Can only apply at any time during the presentation of evidence by the party called. And the time that you are presenting your evidence is when you are making your case, is when you have, at the beginning, when you are called upon, the plaintiff in a civil suit, for instance, generally will make his or her case first. So when you are making your case, the respondent is saying that it is at that time that this provision can apply, subject to the discretion of the court, because it says at any time during the presentation of evidence by the party calling that witness.
Look, I mean, let's...
And the...
All right, so okay, so because we've been talking about the Black's Law Dictionary, I just want to understand the place of the Black's Law Dictionary in our jurisprudence. I mean, you are a law lecturer, and what weight it carries. Also because the counsel for the petitioner disagrees with the Black's Law's definition of an adverse witness, which says that an adverse witness is you can only call someone an adverse witness when he or she is in the witness box. So I just want to know what place, I mean the weight that the Black's Law Dictionary carry in all this.
So we have the laws of Ghana, and I think in the second or third grounds, I'll come to that to explain what the laws of Ghana are and the hierarchy of the laws of Ghana and all that, so we'll be clear at that point. But basically, the Black's Law Dictionary is a dictionary which gives lots of elucidation in terms of the law generally, and it's one of the seminal publications, if you may, that deals basically most of the time with English law, but we usually make reference to it in Ghana because of our colonial heritage, because of the fact that the common law is that which we inherited and all that. So it is authoritative in the sense that it provides meanings to lots of the legal phrases, terms, and all that. But in terms of the laws of Ghana, the Black's Law Dictionary may not necessarily be considered as part of the laws of Ghana. And that is what the petitioner is essentially arguing, that to the extent that, according to the petitioner, there is a statutory provision in the Evidence Act which deals with adverse witnesses and what an adverse witness generally is and the circumstances under which a party or a person may be deemed an adverse witness. To that extent, the court not adverting its mind to that and only citing or quoting the Black's Law Dictionary, then the court had acted per incurium, because the laws of Ghana include the Evidence Act, but do not necessarily include the Black's Law Dictionary definition on anything. That's why he was saying that, and we heard it towards the tail end, that the Black's Law Dictionary's definition of adverse witness simply captures the common law position, which has been, according to the petitioner, modified in Ghana by virtue of the Evidence Act, Section 72.
All right, Doc, we'll explore further with Section 72 and the Black Law Dictionary based on the ruling. Well, we'll go for a quick break. Just hold on for us. We'll go for a quick break. We're talking to Dr. Kwekwajiman Budu, who is a lawyer, is a law lecturer, head of Law Center's Gimpa Faculty of Law, and he's also the founder and executive director for the Justice Foundation. Stay with us. We're going for a quick break. When we return, we'll continue our conversation with him. We'll be right back.
Mama fa, 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 mama fa. C'était femme, Kojobi. 2020 de Mahameba, et de Mekele, cause offer. I go for Dubai and we're share 4 years, but now so the end of the 1 history, 1 foot, scan the band or chairman family. Penny about 2020, but soon you think when Abadi Mahamafa, Mamafa, Mahamafa, Mamafa, Mahamafa, Mamafa, 2020, when you be on pre-cost, Mahamafa, Mamafa, Mahamafa, Abadi Mahamafa, Mamafa, 2020, when you be on pre. Galamse was so Besewakina, or by no cofa so yes. Was the intimate now? What is this cavitas now? What's a sea low bed? Ubegunu, tell you betu. Then Yabro, I'm a need to. A pen of a partner said 2020, but soon you think when Abadi Mahamafa, Mamafa, Mahamafa, Mamafa, Mahamafa, Mamafa, 2020, when you be on pre-cost, Mahamafa, Mamafa, Mahamafa, Abadi Mahamafa, Mamafa, 2020, when you be on pre-share, or buy new Obegu banks. I didn't say the kind of crime went yes. I will bet my arm and I nice. My Mukululu, Namashasi, Pasia and Tiasun Trilu, or better now, so the Moyen. Ahoya, and you 2020 lesson, yeah, mama chance.